From the daily list, item number 1.
That like for 7 crores.
She's challenging the whole.
Yes. Correct. That case is page number 21 and 29. Yes.
My lord, this is a matter. The petitioner approached this honorable court for, my lord, the power of the district council to levy the tax on the entry of the goods into the market, my lord. So they have filed the rejoinder, my lord. I just complete the instruction. After a week, the matter can be heard, my lord.
Which one? When do you want?
Number 1, my lord. Item number 1.
Yes.
Yes, my lord. So I've just received the rejoinder, my lord. They have filed the rejoinder. I just need to.
You want to go through it and
Yes, my lord. Yes, my lord.
the counsel for the respondent submitted that the petitioner have filed a rejoinder and that he requires time to go through the same and address argument. Pose a matter for hearing on so and so date.
That's it.
From supplementary list, item number 1.
Make PG or similar. Make PG or similar.
Yes.
But in this petition, I'm challenging the one orders of passed by the Assessing Authority, which is also found at page 303.
It's coming up for admission.
Admission.
Where is the order?
303, my lord. Page 303.
303.
My lord. My lord, at the top you'll also find this is for the period ending 36/07, my lord. 36/2007. And the order has been
36
passed on,
2007, yes.
my lord. And the order has been passed on 8/3/2003. 23, my lord. Just bottom, my lord.
59 2007 is the order, is page number 303.
The period ending is 36/2007.
Ah,
And the order has been passed, my lord, on 8/3/2023. You're also find just below it. Just below that, my lord.
8323, yes.
My lord. And the order was scrutinized under section 39 of the VAT Act, my lord.
Yes.
Just above. Now, my lord, under the VAT Act, my lord, the period of limitation for the completion of assessment is 5 years.
5 years.
From the 5 years, my lord. Now, section 39, my lord, when the assessment are barred for 5 years, now the scrutiny of the assessment is being done, my lord, after 16 years of the end of the period. And you'll also see section 39. If you just
No, when did they commence? Probably they would have delayed the proceedings.
my lord, they have not started the proceeding at all. There was no proceeding at all.
So when was the first date of hearing?
No hearing, my lord. You also see this is the first time the notice has been given. Order has
So
been
this is the
passed.
first notice.
Yes, my lord. This is the first order. And you'll also kindly see, my lord.
So let the notice go. Let the notice go.
My lord, there are different assessments. Yes, the last assessment is for, my lord, 36/2015. The assessment for
No, how many writ petitions are there, sir? How many writ petitions you have filed?
my lord, I filed the writ petition.
See, don't you have a right of appeal before the authority concerned?
My lord, but when the
Because
order
Supreme Court
is
has categorically held in tax matters, most on tax matters, don't bypass the alternate remedy.
my lord, in the Godrej Sarali, it is said, my lord, that is a pure question of law. And when the question of limitation is there, then the writ petition can be filed. My lord, you'll also be aware, my lord, in Godrej Sarali, it has been said recently, judgment, my lord, that when the question of law is there and question of limitation is there, then the authority has no jurisdiction at all.
So
And
let the
it will also
notice
be-
go. Who is on the other side? Who is going to take notice?
My lord, I will.
See, how can you see the period of limitation is 5 years, 2007, you are taking it 2023,
My lord,
after 16 years.
I will require instruction. And my lord, as per section 65 of the VAT Act, my lord, appeal, there is a provision for appeal under the statute itself, my lord. So,
No, that is right. When there is a delay in initiation of proceedings, why should the person be relegated to an alternate remedy? Is his submission. That is his submission. See, we do agree, when there is a disputed question of fact, when there is a question to be determined, then High Court cannot interfere, saying that they cannot come bypassing the appellate remedy and come before this court.
my lord,
If the facts are not in dispute, you take 1999 4 ACC page 450 judgment, subject to correction, 150 or 450, HPCL case. You will take down,
my lord.
and followed by subsequent judgments also. But one other judgment also your senior friend is relying upon. What is the citation, sir, which you want to rely upon?
No, I'm just giving the citation, my lord. Godrej Sarali, it is there. I'm just giving, my lord. You'll also be giving,
Huh?
just, my lord, few seconds, my lord. I'm just giving the copy, my lord. I'm sorry, my lord. I should
Get a
have.
1999 4 ACC, must be 4 ACC 450, Hindustan Petroleum Corporation.
My lord, in that case, it said, my lord, that if the question is only of law, then the question of, my lord, this is citation, my lord. My lord, this is 2023 SCC online.
2023, 1 minute, 1 minute.
My lord, my lord.
2023
SCC online
online
SC 95.
695.
95 million, only 95.
195.
Only 95.
Only 95.
My lord. My lord, if you lordship permit me, lord.
So judgment of that, the earlier judgment of Supreme Court in 1999, 4 SCC 450 has been relied upon by the apex court,
No,
referred to by the, not relied upon, referred to by the Supreme Court.
My lord, in here the Titagarh paper mill is starting from that original, my lord, first judgment, Whirlpool and my lord, the state of Uttar Pradesh, Mohammed Nu, those have been discussed, and thereafter the finding has been given, my lord. My lord, I may just, if you lordship permit me, my lord, 4 lines,
Yes.
if you lordship permit.
Yes, yes.
My lord, he said, my lord, that unless excessive discretion is shown to be a reasonable purpose, this court will not interfere. In the matter, later decision, this court found the issue raised by the appellant to be precisely legal, requiring determination by the High Court without putting the appellant through the mail of the statutory appeals or Hagee. That follows that from the said decision that where the controversy is purely legal one and it does not involve disputed question of fact, but only questions of law, then it should be decided by the High Court instead of dismissing the petition on the ground of an alternate remedy by being available. Now, my lord, if the assessment period is 5 years and if somebody, my lord, and lordship aware, my lord, the apex court in earlier judgments also said that even if the time limit is prescribed, then also it has to be done in a reasonable period. You cannot do it after 16 years, 20 years, my lord.
Yes. We'll take
So,
the,
my prayer will be that no coercive measures may be taken, my lord.
only you have got a notice, that is all. You will not.
No, my lord, the order, no, lordship is in the order. My lord, the payment has to be made, my lord.
Page number?
Page number 303.
330.
303, my lord.
Yes, 303. Yes, 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 it is it. Hence the scrutiny was completed as under
Section 39, my lord. And it has been said, my lord, the notice has to be issued, and the notice has already been issued, which your lordship find.
Very
My
right.
lord.
See, you are approaching this court after 1 year.
No, my lord, your lordship is 23. I got the
8320,
order.
8323 is the order.
My lord, there
From
are
your,
demand notice was-
Beyond 1 year.
my lord, that's correct, my lord, but since it is prima facie, my lord, without jurisdiction,
Yes, well,
my prayer,
anyhow, let the notice go. Let the notice go. So, you got the judgment.
my lord, I shall again, my lord, reiterate my prayer, my lord, that if your lordship may be pleased to, my lord, say the coercive measures at least till then, my lord, otherwise, what will happen, my lord, they will start tomorrow itself, and March is
No,
March is coming, my lord.
notice, but when the court has ordered notice, they can wait. Your friend has also taken notice.
My lord,
See,
31st March
inform
is
them not
coming,
to do any
then,
coercive steps till the next date of hearing. Inform them.
because 31st March is there, my lord, so what they do, my lord?
Yes, yes. Because when the year ending, the people like to collect the money.
So that start doing the bank
What is
attachment.
the amount? What is the amount determined by the payable?
My lord, different amounts are there, my lord. There are huge amounts, my lord, like the total amount in two
Huge
requisitions will
amount
come
means
to.
you don't include your fees.
So don't include your fees.
No, no, my lord. My fees has no value, my lord.
Yes.
My lord, at least, my lord, at least, I think
What
that
is the amount? What is the amount?
my lord, total amount in two requisitions will come to near about 18 crores, my lord.
How much?
My lord, in crores, my lord, around 18
No,
crores.
if you want to file an appeal under section 65, what is the amount they have to deposit? There's a condition precedent is there. Madam, get the VAT Act.
Appeal against assessment. Section 65, clause 1, it says, my lord, any
You need not read anything. You tell us what is the amount that is going to be deposited. Hindustan Petroleum Corporation. No, 1990, not 1999. This is 1994.
It says, my lord, provided that no appeal shall be entertained by the said authority unless he is satisfied that such amount of the tax penalty or interest as the case may be, as the appellant may admit to be due from him, and such percentage of the dispute tax as may be prescribed has been paid.
Oh, there is no percentage mentioned. He is not admitting anything.
No, my lord, because there is no.
Did you ask for a stay?
My lord, yes, yes. In the here, my lord, we have prayed for this time, my lord.
Stay.
My lord, let me get my instruction, my lord, whether they were within their.
Then why you get instruction tomorrow?
I'll require some time, my lord, at least 1 week time, my lord.
See, the problem is that on 31st, definitely you know about the taxing authority.
My lord.
My lord, is
Only
assurance
they will
from
wait
my.
for the month of March when they have to collect revenue. So they are not the
Well, till the
taxing
next-
authority, they are
well,
taxing authority.
My lord, till the next date, till the next date, my lord, the question management, whenever time is taken.
Let this matter come up after a week, my lord, then we will have the instruction.
We are closing full of next week. You're closing full of next week. And then you deposit 2 crores.
My lord, when the
As an
amount is
increment.
payable.
No, you succeed. We'll pass an order
Right.
saying that if you succeed, the amount will be returned to you with interest.
My lord, your lordship knows that we have to regularly come to this petition before the
Sir,
court.
their intention is to get money for this accounting year, financial year.
But
They can
my
take
lord,
it.
my lord, state is mighty, but industry is the my lord, we are regularly filing petition for getting
See,
refund in
in
the
1 minute, 1 minute. In 1999, 4 ACC 450, Hindustan Petroleum Corporation, Supreme Court has held whether writ priority is appropriate if the facts pleaded of or of such nature as they do not involve any complicated question of fact needing elaborate investigation. High Court may exercise jurisdiction in Article 226. There can be
So there is
no
no-
fast rule in such matters. So,
So in this case, my lord,
1 minute, sir.
my lord, I'm
I'm
sorry.
making some statement on your behalf. You can wait.
I'm sorry, my lord, I'm really sorry, my lord.
For that also you can charge. So minute to minute. Yes. So the Supreme Court has clearly stated that when there is facts are not in dispute, the court can entertain. See, so no hard and fast rule. In this case, 2007, 2023, 16 years. The facts are not in dispute. Unless you say that 2007, you have initiated a proceeding in a period of 5 years, then it prolonged for 16 years. Then you may be justified.
If my lord will see the section 303, page
So
number.
you deposit 2 crores, sir, as an interim measure.
But it will be too harsh, my lord, for me, my lord, to your lordship may see because something is. Your lordship will find that, my lord, when the orders are prima facie illegal, my lord, I am subject to, my lord, your lordship's.
No,
my lord,
he will pass orders. Don't worry about it. Well, admit.
well, let it be 50 lakhs, my lord. Let it be 50 lakhs, my lord. Just as a
No,
token to your
no,
lordship.
no, no.
Demand is of
My
18.
lord,
When senior advocate of your stature is appearing before this court, if you fix a law of 50 lakhs, it will be really low.
Lord, that
It will not
will-
be, you know.
well, that will be
appreciated.
penalizing, my lord. Well, that will be penalizing. Nobody will engage me now. It's thereafter.
Yes. Yes. Admit notice in person. Admit
No, I
notice.
think in both the cases, because it is combined cases, I said demand including both
No,
the
how many
cases.
cases we don't know. Each case. Come on.
Two cases. So in case one case is the demand is very less, Milord.
How much?
This is the first case is there, Milord. The total demand in the first case is 17 crores, and in second case, Milord, only the total demand is 37 lakhs
37 lakhs.
in the second case, Milord.
Yes. So totally put together 2 crores.
Well,
Yes. Admit notice. According to the petitioner, the proceedings have been initiated under the VAT Act, that's Value Added Tax Act, after a period of 16 years. The period for which the action was initiated is of the year 2007.
Not only 2007, not 2007 to I just
1 minute, 2007 to?
2007 to it is 2007.
17, my lord.
2007 to 36 2017.
This was done in terms of a notification, my lord.
23. Still in the beyond 5 years.
My lord,
Yes, sir.
you will see page number 303, my lord, of the first case, my lord.
Yes.
Lecture 2. Page number 303.
30?
3.
Yes.
Here, if we read, my lord, this return scrutinized against account produced, turnover as per accounts produced was found so much, which is tallied with the return submitted. Purchases and sales were vouched for and recorded in details. No ITC claimed was found as per declaration in the monthly return. The unit being eligible under the Meghalaya Tax Remission Scheme 2006 up to 10/5/2014. Scrutiny of return was done as per government notification number so and so dated 2017, which allowed 99% remission of tax with retrospective effect from 1/10/2006.
So when did you initiate action?
Yes.
This is the final order.
To
That
all,
is why, we post a question, when did you initiate action? Suppose you have initiated action immediately and the proceedings are prolonged, we can understand.
now here, my lord, they were entitled to the benefit of remission, my lord, only till 10/5/2014, as per the remission.
You file everything.
My lord,
Then now we help you to get some revenue.
my lord,
And we'll see.
obvious.
For 2007 to 2017.
My lord.
And that the order, the scrutinized, return was scrutinized under section 39 of MVAT Act only on 8/3/2023. Full stop. As there is a delay, and that the proceeding should have been initiated within a period of 5 years, and that is absent in the present case on hand, the petitioner has approached this court. The respondent, after taking notice, would submit that pursuant to the government notification dated 24/5/2017, as could be seen from the order dated 8/3/2023, remission of tax with retrospective effect from 1/10/2006 to all the eligible industrial units was imposed, allowed, and remission of tax was allowed, and order has been passed determining the amount payable by the SSC. Full stop. You further submit that as per section 65 of the VAT Act, appropriate remedy is provided. Full stop. Since the matter requires consideration, in the light of the judgment of the Apex Court reported in 1999 4 ACC 450, and the decision of the and eternal judgment of the Supreme Court in 2023 SCC online 95, we are inclined to grant an interim order on condition that no coercive petition a coercive action shall be taken against the petitioner if the petitioner deposits a sum of 2 crores on or before 31st March 2024. The Apex Court has categorically held that if the facts are not in dispute, relegating for an alternate remedy is not required, and that there can be no hard and fast rule in matters of the High Court exercising the jurisdiction under Article 226 of the Constitution of India. We'll start.
In case I succeed, then the amount will be refundable along with the statutory interest.
Or in case the petitioner succeeds, the amount so deposited pursuant to order of the court shall be returned together with its interest, bank rate of interest.
Obliged.
In second case, my lord, the orders were passed, my lord.
That is the different date. You see the different date also. Totally put together, we are passing a common order. 2 crores.
My lord, but in this case, my lord, the order was passed on section 45 of the
Section?
Meghalaya Act. 45
Section 45.
in the second case, my lord.
In first case, you say the order under passed under section 30 also, and the second case order under party 45. Dated, check the date also. Yes.
I'm highly obliged, my lord,
Obliged.
for getting the opportunity to appear before Lordship, my lord, for the first time.
Huh?
And for getting the opportunity, my lord, to appear before Lordship for the first time.
No. Yes. Yes.
Item number 3.
Please, Lord. My Lord, here, my Lord, contempt proceedings have been drawn by Central Administrative Tribunal, my Lord.
Contempt.
My Lord, what happened here?
Initiated before the tribunal.
My Lord, here what happened, my Lord? The respondent is an employee in Postal Department, my Lord.
Yes.
And in Postal Department, there are circles, my Lord. Every state is a circle. So he is an employee of Meghalaya Circle, my Lord. In fact, Northeast Circle. And he sought for transfer to Bihar Circle, my Lord, on the ground that his wife is working in state government there, my Lord. And there is a provision, my Lord, under the rules that inter-circle transfer on their own request can be entertained, my Lord. Now, my Lord, what happened?
So what is the issue involved transfer?
He sought transfer, my Lord.
If he goes on transfer at request, he will be placed in the bottommost seniority.
My Lord.
Yes.
That is not disputed. He is not disputing that also, my Lord. The problem, what happened, my Lord? For such inter-circle transfer, the concurrence of the parent circle as well as the circle we is seeking transfer, both should be obtained, my Lord. Now, in 2022, my Lord, the Bihar circle accepted that he can be transferred to Bihar. One post was vacant in one of the post offices, my Lord. But that approval was never communicated to us, my Lord, to Meghalaya Circle, my Lord. And then he opposed the CAT, my Lord, the Central Administrative Tribunal. My Lord, I'll take your lordship to the order passed by the Central Administrative Tribunal, my Lord. Page 113, 113.
113?
113. May I read?
What is there wrong in the order? They say you are directed to consider.
But directed to consider, my Lord, what happened, my Lord? In the meantime, the Bihar Circle is saying that their post is not available anymore, my Lord. My Lord, I will next, your Lordship kindly see that letter, my Lord, at page 84, my Lord.
80?
84.
Not available now. Yes. Quoting this, you have to reject this request, that is all.
Now, my lord, what happened, we are
Well, you must know there is no specific direction that the Bihar Circle should admit him. There is no specific order that you should relieve him. Nothing is there. And you see page number 115 is prayer.
my lord, to dispose of the representation, my lord.
Saying during the course of the hearing, counsel applicant submitted that it would be suffice if purpose, if the respondent one is directed to consider the representation so and so, you pass the orders.
My lord, what happened, my lord, only 6 weeks time was granted, my lord. 6 weeks is over, my lord. My lord, sometime,
You
some more
can
time.
seek extension there.
My lord, they have initiated content, my lord.
But where is your friend? Where is your friend? He's not, without hearing, we cannot pass any orders.
He is not here today, my lord. The notice has to be issued to him, my lord. But only, my lord, the contempt proceedings can be kept in abeyance, my lord. In the meantime, we will try to resolve it, my lord. My lord, contempt proceedings, lord, you will see at page 85, my lord.
See, pendency of the writ petition or pendency of the contempt is not a bar for you to pass orders. You pass orders, that's all. Then we'll close this way, saying that the contempt will have to be closed.
But we will pass an order within the next 15 days, my lord. Your lordship permits us.
Not why should you permit? Why should we permit? You can do that.
Because what has happened, my lord, the contempt has been filed only on the ground that the period is over, 6 weeks was granted.
That is right, sir. That is right. You should have filed a petition seeking extension. That you have not done. We'll give time. Did you ask for a
I have asked for stay,
stay for?
my lord.
When the matter is taken for hearing, it is represented with the counsel appearing for Mozi. What is your, how do you spell your name?
N. Mozika, my lord. Mozika.
Mozika. Yes. Mozika, senior advocate, appearing for the petitioner, submitted that the applicant in the original application 043/00248/2023 is sought for transfer from the Meghalaya division to Bihar Circle, and that the applicant's request was not exceeded, he approached the Central Administrative Tribunal seeking for relief. He would further submit that during the hearing before the Central Administrative Tribunal, Guwahati bench, the counsel for the applicant before the tribunal stated that the representation dated 2/2/2023 may be considered, and the tribunal has directed that the communication shall be, that the representation shall be disposed of within a period of 6 weeks from the date of register of the copy of the order. Though a decision was taken by the Bihar Circle initially to absorb or accommodate the applicant at Bihar, the said decision was not communicated to the Meghalaya Circle, and that no decision could be taken at this end. According to him, both the units or circle will have to take a common decision for the purpose of transferring and accommodating the person which is absent in this case on account of non-receipt of communication from the office of the Chief Postmaster General, Bihar Circle, full stop. Even though the petitioner wanted to relieve the applicant before the tribunal to the Bihar Circle, there is a communication dated 23/2/2024 from the office of the Chief Postmaster General, Bihar Circle, Patna, that the post in which the applicant was sought to be accommodated was not available. Full stop. Since the decision has not been taken by the writ petitioner herein, within the period prescribed, comma, the applicant before the tribunal has initiated contempt. Full stop. The writ petitioner willing to dispose of the representation if further time is granted. Full stop. Since without hearing the other side, comma, no orders can be passed in this writ petition. Hence, notice is ordered. However, the contempt proceedings before the tribunal shall be kept in abeyance until further orders of this court.
I'm deeply,
Also, a matter, the specific date in the month of immediately after election.
I'm deeply.
From the daily list, item number 1.
Sir, election in this state.
Let me use it, Lordship.
Yes,
I'm appearing for a sole respondent, Your Lordship.
yes, sir. You sought time in the last occasion to file your objections.
Lordship, 1 week time may be granted, only 1 week. I'll file the objection within a week, Your Lordship.
What is the issue involved?
Lordship, this is an appeal against, this is an appeal against the
263, 260A appeal.
CA, Lordship, whether the relief under section 40A IA of the income tax can be granted, Lordship. That is the issue involved, Lordship.
This also, the request of the respondent to file the objection. What's the matter? After 19th April.
Hello, my Lordship.
Item number 2.
Obliged, Your Lordship.
May it please your lordship. Lordship, as per the last order passed by this honorable court, applicant are supposed to take step for service upon the newly implemented respondents.
But we may be apprised, my lord, the appellant has a limited grievance. Therefore, they move the SLP. My lord, the diary number has been generated. May I just submit the court master? That's a
This is a case where you wanted implement.
implement, my lord. So the SLP has been filed. Case diary has
They
been
implemented.
generated. Case diary has been generated, and the parties are waiting for numbering and listing in view of the coming 1 week holiday. It is likely to be listed after holiday, my lord. So for the time being, madam, may I pray, matter may be taken up after 19, after election.
Yes.
Madam, diary number 11571.
So they filed
The prefer, madam.
an application in diary number 11571 of 2024 has been filed on 11/3/2024. Counsel to the petitioner sought time to get the matter listed before this court immediately after elections. Post the matter after 19th.
Madam. Give them.
Item number 415.
Yes.
My lord, sir. It's an appeal against conviction, my lord. Matter is 30234. Here, my lord, what has happened?
1 minute. Sir, yesterday the papers are all there, no? On this matter. No? Yesterday I wanted to read. Is it papers? I shouldn't show paper book. Oh, available. Same. This is 302.
My lord.
Shall I have it because I was under the impression the paper book is not available. I will read and come
My lord.
so that I can ask you some questions.
Just the gist is that, my lord, it is only a case where conviction is based solely on conventional statement.
I mistook it because my PA, so Lamb said, paper book is available. In the other case, paper book was not available. But in the other case, paper book is available. But here I missed it.
We can have it some other day.
Yes. This is 302.
30234.
Confession statement. Yes. Post immediately after holidays. Give the date. I didn't bring that. Yes. Yes.
From supplementary list, item number 1.
My lord, this matter was heard by Lordship on the last date. I was required to obtain certain instruction, my lord. I have not received. I am praying for some more time, my lord.
What is it? You're not?
I was required to bring the promotion order of his, my lord, when he was granted promotion in 2012, my lord. I have not been able to get it, my lord. I am praying for some more time, my lord.
At the request of the respondent. Who's the matter? In April.
My
Date.
From the daily list, item number 1.
May please, Your Lordship, sir. This is the third round of litigation in this matter.
What is the matter about, sir?
Well, the petitioner was a teacher in an aided school. Now, the allegation was, the original allegation was...
Dismissed.
No. The original allegation was, that she was not paid a salary for a certain period of time. We came before this honorable court, This honorable court directed an inquiry to be caused and to find out who had misappropriated the amount. That was never done. So we had to again come back before this honorable court. This honorable court again passed an order, that an inquiry be done in a time-bound manner. And whoever is guilty of that, an FIR be registered against it. So it was found, that the secretary of the managing committee had actually withdrawn that amount of money, but he had never disbursed it to the teachers concerned. That is one aspect of the matter, What also is the case of the petitioner as well as once that salary was never paid to the teachers, there was a dispute. So, in order to avoid the dispute, the elders of the village along with the managing committee at that point of time had decided, that the school, this is called the Rajpur Girls School, be shifted from location A to location B, which was, there was a meeting, there was a resolution taken to that effect that it be shifted to place B. And it was informed to the district school education officer who accorded his approval. Now, the state has come on the basis of the orders of this honorable court, an inquiry was done. It was found that this person has actually misappropriated the amount.
Petitioner.
No, the secretary of this managing committee. Unfortunately, the secretary had predeceased the inquiry. So at the time of the inquiry, he had already deceased. So it was there was no way of recovering the amount naturally because he was no more. But the problem doesn't end there, The state now comes up with a position saying that the school there now what very interestingly comes out is there are two schools functioning with the same name. One is where it originally was, but there is a resolution in place to shift it, which is not denied by the state. And they say that I am serving in the second school, which is not recognized by the school by the state, and therefore the state is not liable to pay any further pension, further salary to the petitioner. That is the moot issue in this writ petition. Series of affidavits have been filed by all the parties, including the original members of the managing committee, who vouched for the fact that yes, indeed there was a meeting. There was a meeting, and there was a decision taken to shift the school. The matter had come up before this honorable court on an earlier occasion, where this honorable court, after hearing the matter at some length, was of the opinion, because the managing committee now came up with a stance that the petitioner was terminated from service in 2004.
2004?
My lords. So, this honorable court came up with a query, as to if she was terminated, you produce the termination order. So, thereafter, an affidavit has been filed that saying that there is no formal termination order. So, in my humble submission, in the absence of any termination order,
it need to be in service.
I have to be in service, and the dispute regarding the now, strangely enough, originally the same officer who does the inquiry says that the money has been misappropriated. Subsequently, when he files an affidavit before this honorable court, he comes up with the plea that there are two schools, and that is the original school, and this is not the original school, so therefore the petitioner is a nobody. We cannot pay her anything. There is nothing to be paid to her.
But she was employed in the original school.
She was employed, the government records vouch for that. I can take your lordships to the annexures, the government records show that she was also the headmistress of the...
When did he join?
I'll just give the dates.
You have the list of dates?
We prepared a list of dates.
How many years of service you have rendered?
My lords, I joined way back in 1999.
99.
99.
What's your age now?
It's 19.
At the age of superannuation.
I should be close to that, my lord, somewhere. At the time of filing of the writ petition, my lord, she was. She'll be in her mid-50s, my lords.
Mid-50s, yes.
The notes that you took yesterday, just show those notes. Well, I can take a lordship to the orders passed by. I'm sorry.
Principal page number 67. We'll have an idea, some idea. 67 and 7. What is the 67?
Well, 67 is the joining report of the joining of a teacher, my lords. This is only to establish that I was the headmistress at that point of time. Paloda Biswas, secretary headmistress, my lords.
So you appointed somebody in the capacity of headmistress.
Headmistress, my lords. My appointment order, my lords, is there. Where is this? 99/2003 petition.
What do you say, sir? What's your case?
I was the president, my lord, of the then managing committee, my lord. My case is this, my lord. I'm supporting the petitioner to that position, my lord, where, my lord, the salary was withdrawn by the ex-secretary, my lord, and that was not disbursed, my lord. He has misappropriated, my lord. But now he expired, my lord. That is our stand, my stand, my lord.
No, how is the administrator responsible?
My lord, I cannot follow, my lord.
How is the administrator responsible?
I'm not for the state, my lord. I'm for the president, my lord, of the then president, my lord.
So you are supporting the case for the
Yes, yes, my lord.
As a matter of fact, his affidavit vouches for the fact, my lords, that there was a decision to shift the school.
Yes. What is your case, sir?
My lord, the state, on the other hand, has been conducting several inquiries, my lord. Out of which, my lord, I'll take to the affidavit filed on 15/6/2019 by the administrative officer, my lord. Page 8, my lord. This was an inquiry, my lord.
Affidavit dated
16/6/2019.
10/6/2019.
Yes, ma'am. By the administrative officer.
1 minute. 49.
Bringing on record the spot inquiry report of subdivisional school education officer.
1 minute, sir. This is additional affidavit.
Yes, my lord. My lord will kindly come to page 8 of the affidavit, my lord. This is the inquiry report submitted by the then subdivisional school.
1 minute, 1 minute, 1 minute. Page 8. Yes.
May I read, my lord?
8 March.
Yes, my lord. 8 March 2019, my lord. In pursuance to your esteemed office order under reference, I have been interested to conduct a spot inquiry into the Rajpur Girls SSA school for authentication of the status of the matter of dispute between the two parties, my lord. My lord, thereafter, my lord, may I come to the third paragraph, my lord. That, sir, as per my finding, it is to be pointed out that in the year 1999, Rajpur Upper Primary School was established at Rajpur with Sobeda Khatun as BA and Srimati Faluda PU, Srimati Tanuja Begum PU, Srimati Moriam Begum PU as the teaching staff of the school. The Rajpur UP school was taken under SSA in the year 2002, and a regular managing committee was duly approved by memo dated 7th May 2003. In the meantime, a sanction of rupees 78,000 only has been released for the teaching staff as monthly honorarium of the school. But suddenly a dispute arose between Srimati Faluda Biswas, that is the petitioner, and managing committee for fixation of the lump sum monthly honorarium, and for that this Srimati Faluda Biswas remained absent from the school. Finally, the managing committee terminated Srimati Faluda Biswas from the school on 16/7/2004 due to her absence for consecutively 3 months without any leave. It also has the termination letter at page 10, my lord, which was issued by the managing committee, the secretary managing committee to the petitioner. Page 10, my lord.
Yes.
And page 11 is the resolution of the managing committee, which was put forward to the government, my lord. This was the resolution of the managing committee, my lord. The termination order was issued.
Who is appearing to the committee?
My lord.
From the then committee, Lord.
You are appearing to the committee.
Yes, sir.
How are you going to sustain this order, even assuming this termination is there? First of all, it has not been communicated.
Yes, sir. Till now,
No, without inquiry, how can you terminate the teacher?
She was absent for 3 months, Lordship.
Subject to?
She was absent for 3 months.
No, you can terminate.
She formed another.
So somebody absent for 2 months, you can terminate the services.
She formed a new school.
Should you not issue a memo, show cause notice, a charge sheet, seeking explanation, conducting inquiry, appointing an inquiry officer and thereafter conducting inquiry?
Your Lordship, after we issued this letter, she formed a new school nearby, Your Lordship, in the same name.
That's what you have stated. That's what you have stated, the same name in the same school.
Yes, sir.
But the president comes and says that the school was shifted and there was no termination.
Till now, the termination, she has not challenged the termination order. Your Lord.
How many years she has got, according to you, sir?
From 1999, my lords,
99 to?
till 2014, my lords, till 2024. She's continuing. The school is continuing, my lords.
Where is the proof of your date of birth?
It's date of birth. It is there, my lords. Lordships, just bear with me for a second.
What is her ID card?
It is there, my lords.
She's the next ID card.
My lord,
Is there any provision for VRS, voluntary retirement? Or
Aided teachers, my lords, I don't
they
think.
are unlike the government servants, my lord.
uh,
They are totally under the control and management of the managing committee, my lord.
is there any provision for you to disengage them so that they will get the pension and benefits? If you resign, you will not be entitled to.
My lords, they are not.
Tamil Nadu Group 23 is there. If a person resigns, they will not be entitled to the pension until past services will be given a goodbye. What is the position here?
My lord, they are
They are not entitled to any pension, my lords, either ways.
If they resign, they are not entitled to.
Even if they-
dismiss, you are not entitled to.
My lords, even if they superannuate, they are not entitled. Even on superannuation, they are not entitled to pension.
What is it you are entitled to?
My lords, they are entitled to gratuity and the salary, my lords, the leave salary and other things. That matters again, my lords. There is
Who has
a.
to pay the amount?
My lords, it is sanctioned by the state and disbursed by the managing committee.
It's a aided school.
My lords. That matter is that issue is
What is the
independent
amount?
for your
What is the
lordship.
amount? Quantify the amount. Any idea?
So I'll have to quantify it, my lords, because she has not been paid anything since from that date,
From 2000?
2004.
20 years.
My lords.
Gratuity. Why don't you pay some compensation and give a quietness to the matter? So she need not come to the school.
My government has no provision of granting compensation to the.
Not compensation means gratuity. Not, we are not saying. Wrongly you sometimes the wrong words give you.
Totally under the control and management of the managing committee. And
Correct.
managing
Salary is being disbursed by the
State.
college or the school committee, is it not?
Yes, my lord.
You are funding.
Not this.
We are funding only for 3 teachers, my lord. Not for all the teaching staff. Only for 3 teachers, my lord, under the SSA norm, my lord. Only for.
She is one of the teachers.
No, my lord.
Is it not?
Yes, my lords, it is there.
She is one of the teachers.
She is not an SSA teacher or anything, my lord.
Yes, my lord. That time when I was the president, my lord, she was the teacher, she was the headmistress. And
That very affidavit that your lordships were made to read, my lords, was pointed out by my learned friend. If I can just take your lordships to the last page of that affidavit. I'm sorry, this is not paginated in my copy. 17, 18. My lords, this is of the office of the secretary. If your lordships have, my lords, this is a handwritten document.
Which one? Page number?
Page of that affidavit dated, my lords, June 2019. The one that.
Page number. Page.
I'm sorry, in my copy it is not paginated. It will be 17, 18, 19, 20, page 20, my lords.
Page 20 of?
That affidavit, my lords, of June.
Affidavit dated?
My lords, June 2019. Filed by the additional affidavit filed by the administrative office.
22nd May 2015. No.
19, my lords.
10 to 19 days. 10/6/19.
My lords. The last page, if your lordships kindly have a.
1 minute. Of the affidavit.
Lordships.
Para?
No, it is an annexure, my lords.
Annexure.
The last page of that affidavit is a handwritten document.
Page annexure number, page number?
My lords, it will be page 20. 19, 20. It will be page 20. This is the letter, my lords.
1 minute. 1 minute, sir. Page number 20 is on. Is a resolution.
I'm sorry, in my copy it is.
my lord, if my lord come to my affidavit, my lord. My affidavit is dated, my lord. 16 September 2019, my lord.
16?
16 September 2019.
What is this?
91 to 103, yes.
And this is the affidavit of.
1 minute, sir. This is the affidavit.
Yes, my lord. If my lord may kindly come see para 4, page 3.
91 is the resolution. Page number?
Read, my lords, of that affidavit.
Sir?
3.
Page
3,
three.
my lord. Yes. Para 4.
Para 4.
1 minute.
If I am permitted to read, my lord.
1 minute, sir. Resolution 2, page number.
My lords, this is the affidavit dated 16th September 2019. And it is filed by one,
Respondent number 9.
Suleiman Haq.
Page number 3, yes, para number?
4, my lord. You are permitted to read, my lord.
Ah.
That initially one so-and-so was appointed as the headmaster and the writ petitioner was appointed as the assistant teacher of the said school by the managing committee. But after a few days, as per the instruction of the government, the managing committee appointed the writ petitioner as the headmistress of the school and she joined in the school on so-and-so date, that is 1999, my lord, as headmistress of so-and-so school. And so-and-so was appointed as the assistant teacher of the said school. The founder teachers of the so-and-so school were Faruda Bishwas, my lord, the petitioner herein, as a headmistress, my lord, and the other members, my lord. My lord, if my lord, can you produce para 5, my lord? The next page. That in the year 2002, the school was taken under the SSA, and in the year 2004, the government sanctioned an amount of so-and-so to the schools, to the Rajpur Girls Upper Primary School as salary of teaching staff for the period of 2002-2003. The said amount was withdrawn by the joint signature of me and the secretary of the managing committee, late so-and-so, and the said amount was kept with late so-and-so, my lord. And this Amount was never disbursed to the petitioners and other teachers also.
This is from where the dispute starts, my lords. The money was taken, never paid to the teachers. When the teachers confronted my lords, he went on another line. So there was a resolution to shift the school. And very interestingly, my lords, what appeared...
Where is the handwritten portion?
My lords, I was trying to point out to your lordships, my lords, of the affidavit, the first affidavit dated 10/6/2019, which your lordships were referring of the administrative officer. This is not page in YouTube. Is it part of that?
16/9/2019.
My lords, no, my lords, this is June 2019, my lords, of the state.
Yes. Page number?
Page 20, my lords.
Only up to 18 is there, 17 is there.
Till 17, even me, my lord, it's 17.
This is, my lords, the copy of the resolution, right, which, my lords, the
Up to page number 17 alone is here.
my lords, my apologies, this is what I have. I think, my lords, I'll go by what is there in your lordships.
The handwritten is resolution number 1.
Yes, my lord.
That's what you want to read.
No, my lords, this is page 20 here, but then does not appear to be in that affidavit. But this is the letter, my lords, which basically, my lords, is the recommendation by the managing committee to the government that I am the headmistress, appointment letters and identity card should be issued to me. Unfortunately, that is not there in your lordship's affidavit.
Not there, there, types it.
I have never filed that with me.
But he is having a copy.
I can file this by way of an affidavit, my lords. I can bring it on record.
That is right. Now the issue is, why don't you pay some gratuity and some back wages so that we can give a quietus to the matter? You are going to find she is the teacher. School is in granting aid. Why don't you pay some amount so that we can give a quietus to the matter?
My lord, she was already terminated in the year 2004.
There is no proof.
But the state says in an affidavit that there is no formal order of termination. That is on record.
Sir, your decision in the resolution is not sufficient.
My lord, the termination letter is being issued by the managing committee, my lord.
That you have shown. That is not served. It's a decision taken by the committee. Circular taken by the committee. Where is the proof?
Well, there is a subsequent affidavit filed by the same administrative officer on 27/2/2020 on the basis of an order passed by this court regarding this very issue.
27?
27/2/2020. They filed an affidavit, additional affidavit filed by administrative officer. This is sworn by one Mr. N. Bhomik.
Oh, yes.
If your lordships kindly have page 2, paragraph 2. If your lordships have it, my lords, may I just read paragraph 2, my lords? That the petitioner above named was appointed by the school managing committee by resolution number so-and-so, which was approved by the joint director, mission coordinator, SSA. The same was signed and sealed on the body of the resolution itself without any formal order being issued by the then so-and-so. Similarly, the school managing committee terminated the service of the petitioner by resolution number so-and-so dated so-and-so, bearing the sign and seal and approval of the memo of resolution itself by the joint director, without issuing any formal order of approval or termination by the joint district mission coordinator, Dadangiri, West Governance. So there is no formal order of termination.
What is it?
My lord, we are the approving authority, my lord. All the decisions were taken by the managing committee, school managing committee, who are the appointing authority, who are the...
Sir, my question to you is, suppose the teacher has retired from service. What are the benefits, leave alone this case, what are all the benefits that the teacher is entitled to in aided school?
My lord, as per the government norms, my lord, they are only entitled to the salary, my lord.
Salary for services rendered.
And
Then leave encashment.
beyond that,
They are
under no
they are not entitled to leave encashment.
the state is under no obligation to pay the leave encashment to the teacher, my lord.
Yes, it is for the committee to pay.
It is the managing committee.
Correct. What about gratuity?
Gratuity, it depends upon whether they have been, whether the managing committee has been making any requests and all, my lord. It is not.
So when a request is made, the government will pay the amount.
No, my lord.
Ah.
It has never been the practice, my lord, that gratuity will be paid by the government, my lord.
Who will pay the gratuity?
No,
See, you will not pay the gratuity to them. What is the amount you are giving to the committee so that they will?
No, my lord. Our obligation is only to the extent of granting aid to the teaching staff, and from time to time the money is being dispersed for aiding the.
So beyond that, nothing.
Beyond that, nothing. There is no other obligation on the part of the government, my lord. Only salary, my lord.
This entire issue of payment of pension and gratuity and other issues, is an appeal.
No, pension is not eligible. You are not entitled for pension.
Well, that matter is seized of by your lordships in an appeal, That is, in another connected matter, all the teachers of aided schools are before your lordships in an appeal. The matter has been admitted.
Pension under the old pension scheme.
Lordships. We are referring to that Kothari Commission report, which says that all these schools have to be brought in together at par. And since the government has pervasive control over these schools, so therefore the government, they have to be treated at par with government teachers. And
then we will decide whether what is the back wages to be paid. You pay the amount, get it from the government. That's all. You pay.
It is the
2004 to 24.
My lord, at present, I am not the president of the school managing committee. There is a new set of people, my lord.
Who is appearing for the new set of people?
Who is it?
You are appearing. He is appearing.
Only the 10 members. I am appearing only for the 10 members of the management.
But there are 10 members from the committee.
Yes. Now new members has come, so I have to take instruction. I've made a party only when
the managing committee itself is a party.
Not way. You can't say tomorrow another person may come, day after tomorrow another person may come.
No, Lordship, because the managing committee is renewed every 3 years, Lordship.
See, managing committee is a party, is it not?
Yes, it is.
Managing committee is a party to the case. Irrespective of a change in the committee, that person will have to represent. You can't say X has changed, Y has changed. Committee is before this court. So the committee will have to pay the money, reimburse from the government, the eligible amount. That is all.
Lordship, can this better come after vacation? I'll seek proper instruction because the person I'm representing here is all the 10 members of the managing committee.
Under what heads you will be entitled to pension? Suppose the division bench going to hold that teachers are eligible for pension. Under what head you will be entitled to pension?
So I'll have to just examine that aspect because I'm sorry, I'm not prepared with that matter. But what has happened?
If say that you give a quietus to the matter, accept some X amount. So you will be relieved from the school.
Lordships.
Once you are relieved, pursuant to orders of the court, you are getting relieved, not to give a. The court can also say that you will be entitled to gratuity and pension in accordance with law, provided the same is applicable or extendable to you.
Lordships.
If that is the case, till the division bench decides, you will not be entitled to pension. But however, you will be entitled to gratuity because the committee will have to pay. The committee will have to make a demand to the government to reimburse the amount. That's one aspect.
Lordships.
This order, which I may pass, may not prejudice your case in the appeal,
Lordships.
saying that the court has relieved. It's not attending the age of superannuation. So you are not entitled to pension. There should not be a decision on that ground. And one more round of litigation not going to help you.
My lords.
You will have to, committee will have to pay. There is no communication with regard to termination. A decision has been taken to shift the school from one place to another. The another school commenced by the so-called, by the writ petitioner cannot be accepted. Then in terms of the order, the affidavit filed by the parties, it is very clear the termination order has not been served. Without serving, it cannot come into effect.
My lord, section 9 of the Meghalaya School Education Act makes it compulsory, even if it is an aided school, they cannot be reduced or any kind of punishment inflicted on any of the teachers, my lords, without the approval of the government. It has to be communicated to the government. Government has to then take the procedure and then pass an order.
So they have to confirm the order decision taken by the committee.
My lords, it says, my lords, that the state government, subject to the rule that we made on no employee of a recognized private school shall be dismissed, removed, or reduced in rank, nor shall his services otherwise be terminated, except with the prior approval of the competent authority. It cannot be a post facto approval, my lords. They have to communicate what is to be done.
So prior approval need to be
taken from the inspector of schools. So otherwise also, my lords, the termination goes.
So there is no order of termination by way of law.
Yes. Actually, just seek 2 weeks time. Actually, we seek proper instruction.
Petitioner, administrators have come forward.
I inform that
The sounds of prayer. The case of the petitioner is that she has been knocking at the doors of this court for more than once to redress her grievance, and that amount of rupees 78,000 was said to be misappropriated by her and others. Full stop. Pursuant to the orders of this court, inquiry was conducted, and it was found that the then secretary, who is no more now, has committed the misappropriation, and that the writ petitioner has not done any illegal act. We further submit that she is in service, and from 2004 onwards, not even a pie has been paid, and that the teacher has not been placed under, or the administrator has not been placed under suspension, or an order of disengaging her services has not been communicated. We would further submit that when a decision is taken to disengage the services of a teacher, prior approval of the government is required, and post approval will not ratify the illegal act of the committee, managing committee. The council appearing for which respondent, sir?
Respondent number 9, my lord.
9.
Yeah, the president, my lord. And
respondent 9 was the president, would submit that the teacher, the headmaster was a regular teacher working in the school, and the school was shifted from A to B, a place particular. We can mention the place, from this place to this place. And that she continued in the said school. There was no disengagement of her services. The other committee members who are represented by so and so would submit that
10 to 14.
10 to
14.
10 to 14 would submit that the managing committee has changed, and that he'll have to get instructions. We make it very clear that when the committee is a party before this court, irrespective of change of persons, there should be a proper instruction to represent before this court for the court to pass appropriate orders. The council appealing for the government would submit that the teacher, the headmistress or teacher was disengaged as early as in 2004 by the committee, and that there was no granting aid paid to this teacher, and that only for teachers grant is extended. Correct?
That is the normal practice, my lord.
Full stop. In case of any non-payment of salary to the teachers, the committee will have to make the payment, and that if any request is made and the same is found to be genuine, the government will pay the same. However, if we further content that the gratuity amount is also got to be paid by the committee, and depending upon the request, the same will be examined either to be extended to the committee or not. Mr. So, senior advocate, in response would submit that teacher has not, the petitioner has not attained the age of superannuation. The other part, a batch of cases pending before the division bench with regard to extension of old pension scheme. And at this distance of time, he is unable to state as to the benefits that may be extended to the petitioner in case she succeeds in the writ petition, partly, and this court is going to relieve her from services by accepting, by directing a payment of full or portion of back wages, apart from gratuity that she may be entitled to. In order to enable the respondent 7 to 10
to 14.
10 to 14 to get correct instructions to be placed before this court, and also by the writ petitioner to make submissions about the nature of benefits that may be extended to the teacher by way of pension in case she succeeds in the writ appeal. She succeeds in this writ petition partially, so that addition could be taken as to the benefit that may be extended to the writ petitioner.
My lord, only one small which submissions which I must have slipped, my lord, is that she is the petitioner herself has established another school, my lord, which has also come during the course of inquiry, which is part of the
That is what they're trying to say.
It is a submission by the council to government that the writ petitioner has admitted in the inquiry that she has started the new school.
No, I have not admitted, Millets.
No, she has not admitted. That is what he says. I'm recording his submission. The government submit that the writ petitioner has stated in the inquiry that she has started a new school in which she was registered, and this has nothing to do with the original school, which was said to be shifted from A place to B place. For further hearing, post the matter immediately after 20th April.
Yes. Beautiful. I'll mention.
See, give a brief note. One of you give a brief note.
Yes.
Your case, his case.
I'll prepare a brief note, my lord, that's circulated with my friends.
What's your submission? What is his submission? Their submission, so that you will have.
Balance.
You take it that you are an amicus, like that you present. So it will be easy for me to dictate full order.
I'll circulate it to them also, Millets,
so that what is there in the record, so I'll be in a position
to make your documents
yes, yes.
I'll do that. Obliged.
Item number 2.
You be there. It's your matter.
Yes.
Lordship, item number 2, I need small accommodation, Your Lordship. We could get the order of 4th March only uploaded yesterday.
At the request of Additional Advocate General, post the matter after 20th. You're going to argue?
No.
My friend has already argued, Millets. I have started to push my friend.
In fact, I was talking to some of the advocates in Madras.
Lordship.
I couldn't recognize his name. I said one senior advocate is encouraging the junior to argue and is sitting next to them and instruct them to do that. Whenever I have, or a bench has got a doubt, we'll ask the same. So I've given credit to him. So I want all of them to follow the. Well, of course, government will not be possible. They are not possible because you have been specifically instructed to do that.
Absolutely, Lord.
But senior advocates permit them so that they will be in a position to be bold to address the court.
Absolutely.
They must come out of the fear. It's very important.
Right.
Okay.
Item number 3 and 4.
The student petitions, my lord, is also a connected matter. With regard to termination of the teacher, SSA teacher, by the authorities without any issuing show cause notice.
Without any?
Without issuing any show cause notice, no inquiry was conducted. He was never allowed to participate in the proceedings. And my lord, no copy of the termination order was served, except he comes to know after he received an affidavit filed by the state government.
What is the WP 473 of 2019? That's also listed.
My lord, both the matters
Both the matters are
together, my lord.
Together.
Same party, same parties.
My lord, this will be accommodated for another day, Your Lordship.
When you are terminated without show cause notice, what is the relief you expect?
Your Lordship, in this case, his initial appointment was also illegal.
Initial appointment?
Was illegal, Your Lordship.
Illegal?
Yes.
How do you say that? So that's the only point. That's the only
He has
point.
not followed any procedure. President is appointed, and it was in dark about 2 years. And after this, he came. There, so
He is also a teacher.
Teacher, man. I mean, it's a scheme.
How many years he has been working? He or she? He. Nazrul Islam.
Man.
How many years you have been working?
after that, Your Lordship,
No, how many years you have been working?
My lord, in fact, in one of the affidavits we filed, my lord, we've showed the attendance register. His name does not feature anywhere, my lord, in the attendance register. 2 years. There is no evidence of his signature in any of the attendance register, my lord.
You are appealing for?
I'm for the managing committee.
For the?
Managing committee. Managing committee.
He is appealing for the managing
Appealing
committee.
for the managing committee, my lord.
At the request of the
And-
managing committee. Who's the matter? Yes.
I'll prepare the list of the
So how many years you worked?
from 2014.
14 to?
14 to till date, man.
Till date?
Till date.
Still working?
He's still teaching.
That's
Teaching where?
Teaching in the same school.
Same school?
Yes, but salary is not paid to him.
He is not teaching it.
How can there be a termination?
I don't. I'll open the record. What is ready? I'll prepare the list of dates, my lord, so that.
Give the list of dates.
Yes.
See, that is the reason why, I picked up about 50 cases. Posted 5 cases every day. Whole of March.
Yes.
If you utilize my services, I'll dispose of as many service matters as possible. Then you can't expect me to do the work in the month of July and August.
Item number 5.
I know.
My lord, obliged.
Adjournment. 2020.
Yes, my lord. Item 5. This is a my lord, cancellation of selection process, my lord, for the post of Ayurvedic doctor after I have stood successful, my lord.
Ayurvedic?
Doctor.
Been terminated.
No, my lord. After I was in the selection process, after I succeeded, my lord, they have cancelled the entire process, my lord, on the ground of nepotism, my lord. And there was an inquiry conducted and there's no finding to that effect. So that is the case, my lord. The main respondent is the Public Service Commission, my lord. Meghalaya Public Service Commission.
Who is appearing for public service?
I'm there for the public service commission.
But I prepared a list of dates, my lord. Yeah.
There is a technical difficulty insofar as this matter is concerned, well, as the maintainability of this matter. Maintainability, Millets.
Oh, maintainability.
What happened is, Millets, they originally came before this honorable court challenging the interim order of keeping the selection process in suspended animation. We came before this honorable court, Millets. We apprised that that order had attained finality by a subsequent order, Millets, by which we said that written examination would be made mandatory for all appointments. That writ petition came to be dismissed. And the finding of the learned single judge is, Millets, that the process of written examination cannot be interfered with by this court. They challenged this order in appeal. In appeal, Millets, they withdrew the appeal with liberty to again challenge it. Now, my lords, whether a coordinate bench can sit in appeal over a decision already rendered, my lords, saying that...
Let it was withdrawn with liberty, my lord, to challenge the subsequent orders, my lord.
So you're challenging the subsequent order.
The subsequent order finds mentions, my lord, the subsequent order finds mention in the order of the single judge. The single judge was conscious of the subsequent order, my lords. I'll take your lordships to the finding of the learned secretary.
Yes, my lord. I prepare the list of dates, my lord.
Your lordships can hear us on the issue of maintainability first, my lords.
You address both.
My lords.
So, maintainability, yes, you address the argument on maintainability.
My lords. But I'll draw your lordship's attention quickly to my lords, page 61. This is the finding of the learned single judge, my lords.
61.
Extra copies.
Yes, sir.
Well, it's paragraph 6.
Yes.
Further, after analyzing the submissions, affidavits, and the confidential file, I am of the opinion that there may be some mistake and error done somewhere. Therefore, the remedy left to instill confidence in the minds of the public is to conduct a written examination with proper syllabus. In the past few years, it seems there have been a lot of scams regarding examination results. It should not occur again and again. Otherwise, the confidence of the people in the examination system is bound to collapse. And furthermore, when any examination is called for, any relation or known person of any candidate should not be in the panel of interview. Therefore, I am not in a position to interfere with the written examination as decided by MPSC.
Yes.
In case the candidate who appeared in the earlier has overage, his age is to be condoned. So, my lord, the finding is that the decision of the MPSC, my lords, to hold a written examination cannot be interfered with. This is that subsequent decision which they brought under challenge here in this writ petition. Because in my counter affidavit in the earlier round of litigation, my lords, I had categorically pointed out that the original decision...
Which order is now under challenge?
My lords, this order of the written examination.
But can you have the decision?
I'll just take your lordship, my lords. That your lordship would find at page 774.
The three orders are under challenge.
1 minute.
The decision is page 74, my lords. Now, interestingly, in this writ petition also, this decision is not under challenge. May I take your lordship, my lords? This is dated the 25th of May, 2017.
So, yes. But we are under challenge.
This is not under challenge even in this writ petition.
Not under challenge.
Not under challenge. What they have challenged is, my lord, a communication of this order to the petitioner.
Huh?
What they have challenged in this writ petition is this order was communicated to the petitioner saying that you are required to sit for a written examination. That has been challenged.
Where is it?
Well, it's that your lordship should find at page 39. Annexure 7, page 39, my lords. The penultimate paragraph.
1 minute. Yes.
Well, so they have not challenged the decision, they have challenged only the communication of the decision to the petitioner. That's one aspect of the matter. Then, in view of the finding of the learned single judge, well, that was carried on appeal. Your lordship will kindly peruse the order passed on the appeal. That's page 71, my lords. Operative portion is available at page 73. Paragraph 4 onwards, if my lords kindly have a look. And paragraph 6 is the directions. So what I'm humbly submitting before your lordships is, if the division bench, my lords, had interfered with the orders of the learned single judge, to a limited extent, my lords, setting the matter to naught, then probably this writ petition would be maintainable in its present form. But here my lords are sitting singly, and there is already a finding by the learned single judge, my lords, in the earlier round of litigation, saying that this decision of written examination cannot be interfered with.
Yes.
Yes, my lord. My lord, as pointed out by my learned friend at page 73, my lord, while withdrawing the writ appeal, my lord, the observation of the court is subsequent order of 26/5/2017 has not been challenged. So, my lord, we sought liberty to withdraw the my lord, proceedings altogether. When I withdraw the writ appeal to file a fresh writ petition, it is the entire proceedings that is being withdrawn, my lord.
So the finding that
You have not withdrawn the writ petition. Suppose you have withdrawn the writ petition, then the entire thing is at large.
only the appeal.
Only appeal alone has been withdrawn.
So
You should have withdrawn the writ petition with liberty. Then you are entitled to challenge.
that's where the technical hitch comes in.
My lord, to file a petition afresh, my lord,
Whatever it is.
not appeal afresh, my lord.
That is right. You are entitled to file a fresh writ petition, a subsequent order. The finding insofar as the written examination is a must have become final. Number one. Number two, send the communication asking it to participate in the examination, not the other one which is mentioned on page number.
My lord,
Page 73.
This order, my lord, is
sorry,
with respect to the advertisement was with respect to many posts, my lord. With respect to many posts, I'm concerned with only one post. Can you have the advertisement, my lord? Can you have the advertisement?
Please see your prayer.
Yes, my lord.
Please see your prayer.
My lord, my prayer, I'm challenging the notification dated 6 April 2017. My lord, letter dated 26/5/2017.
With page number?
Page number 18, my lord.
18.
Yes, my lord.
Is letter dated 24?
My lord, 6th April 2017. The
Yes.
second is 26/5/2017.
26?
5/2017. There are two letters of 26/5/2017 and order dated 24/5/2017, my lord. 24/5.
The order by which we have recalled.
Where is the communication dated? Which page is there? 6/4/2017?
6/4 is at page 37, my lords.
37.
That was the original challenge in the writ petition, first round.
Yes.
Then, my lords, 26/5 was the letter by which we said, my lords, written examination, you have to sit for it.
Page number?
My lords, that is at page 39.
Yes.
That letter of 26/5, my lords, falls from the decision of 25/5, which I pointed out at page 7.
No, there are two communications. One is 26/5/2017, the other one is 26/5/2017.
Both are 26/5, my lords. Those are both the letters asking her to sit for the examination.
Both.
My
That
lords.
is also page number 2019.
My lords, 39 and 40.
40.
These are both asking her to come and sit for the examinations. But they
Then page number,
these are communication.
24/5?
I'm sorry, my lords.
24/5.
25/5 has never been. 24/5 is, my lords, at page 48.
Recalling the result.
40.
My lords.
Recalling the
40.
Yes, my lords. 48.
48.
48.
Recalling the result, my lord.
These are all, my lords, these all decisions culminate out of the decision of 25/5/17, which is not under challenge.
No, my lord. This order is dated 24th of May, my lord, 2017. My lord, which recalls the result of 4th April 2017, my lord.
Page 48.
Sir, you're right.
Yes,
You
my lord.
have challenged the subsequent order.
My lord.
But it is a decision for the purpose of conducting written examination.
My lord, can you understand? This order is dated 24th. That is predated, my lord.
What do you mean by predated?
Predated means, my lord, it's a day before, my lord.
No, predated means we understand what is the meaning.
The order passed on 24th is to recall the result, my result, my lord, which I succeeded, the notification of my result. The decision is taken on the next day, my lord. Can you have page 48 and page 74, my lord?
14?
Page 48, 48, my lord. This is dated 24th of May 2017. Page 48 and extra 11. This is to inform you that notification dated 4th of April 2017.
How did you get selected? How did you get selected?
By the selection process which they have carried
Which
out.
is held to be not correct.
My lord, that is decided on the next date, my lord.
No. Is it based on the written examination?
No, my lord.
24/5/2017 they have withdrawn.
Yes, my lord.
Correct? That is the earlier notification.
Correct, my lord. On the basis of inquiry, saying that there's nepotism.
Correct. It is only the interview, not the written examination. These things have been considered by the judge.
But the decision is on the next day, my lord, page 74.
70?
Page 74, my lord. What my learned friend is pointing out, my lord, that is the next day, my lord.
You got it on record.
Page 74.
No, what my learned friend is saying
On the day before, my results has been cancelled. On the next day, they take the decision, my lord.
That is right. This order you not challenge that.
My lord, but this order has come subsequently, my lord.
Which one? After your writ petition?
No, my lord. After the results have been cancelled, my lord.
Whatever it is.
And kindly have the inquiry. Kindly have the inquiry, my lord. Inquiry report, their own inquiry report, my lord, which your lordships will find at page.
It's the page 57. 57.
Page number?
57 minutes.
57.
57.
57, my lord. This is the report of the inquiry, my lord. Just a half-page report. This was conducted in May.
1 minute, sir. 57. Yes, sir.
Yes.
You inquiry revealed the selection process direct interview. Yes.
Yes, my lord.
Yes.
On scrutiny, second paragraph, my lord, on scrutiny of the complaints, it was found that there have been allegations of nepotism in the selection process, and as much as one of the members of the interview board, Srimati so-and-so, Lalu, was related to one of the selected candidates, that is Disaka so-and-so Lalu. So allegation is that they are related. Then subsequent paragraph. It was however revealed that Srimati S.M. Lalu, the honorable member of the MPSC, and Srimati Disaka Lalu only belong to the same clan. They are not related.
Yes.
Be that as it may, to instill the confidence of the public in general and the candidates who appeared for the personal interview to the post of Ayurvedic physician, in particular, perhaps it may be proper for the selection process in the MPSC to be above board from all allegations.
How can an interview be conducted and 100 marks be given, sir? Supreme Court has categorically stated that written examination should be 85% and interview should be 15%. That's the Supreme Court.
Their own advertisement, my lord. Kindly have.
Which is why, my lords, we decided to do a minute.
Just a minute. Their own advertisement, my lord, at page 24. It starts, my lord, various posts.
24?
Yes,
of their affidavit?
Of my writ petition, my lord.
Your writ petition?
Yes, my lord. This is their advertisement at page 24 and extra 3, dated...
1 minute, sir. 24. Yes.
Dated 26th April 2016, my lord. There are various lists of posts, my lord. And the relevant post your lordship will find at page 26, serial number 13, is Ayurvedic physician. Now, my lord, regarding the process of selection, your lordships will kindly find at page 33. page 33. Middle of the page, my lord, it says para 8, method of selection. This is their advertisement.
Written examination followed by personal interview. Yes.
The final selection recommendation of suitable candidates against the vacancies notified in this advertisement shall be made by the commission through any of the following process. Number 1, number 2, number 3, number 4, number 5. They have chosen number 5 themselves, my lord. I participated and I succeeded, my lord.
Correct, that's wrong. That is wrong. That's what we are saying. Sir, I don't remember the case name, but the Supreme Court has categorically held that for the written examination, there should be 85%. I think in that case, they wanted to have 40% or 50% for the interview. They said, you can have 10 papers, you can have. Even for interview also, you can have 100 marks. But when you convert it, 85% for written examination and 15 for interview.
Correct.
That's what Supreme Court says.
It's their own advertisement. They conducted the process.
I'll try to get the judgment and quote it. If you have got any
allegation,
This one, if I'm not mistaken, this is Ajay Hasija versus Khalid Mujib Sarawai, 1981 SEC. It says that for oral interview for selection to senior post may be the only test, but for young candidates whose personality is yet to develop and it is too early to identify the personal qualities are to be subjected to written examination.
That's right.
So they say
written examination marks should be only 85. Is it there?
No, I'll just have to examine This is not there, but probably this is what your lordships are referring to. Because
there also, no, when they clarify this, I also can say that written examination should be 85 and 15 should be the interview.
For 15 marks to interview.
Now, my lord, kindly have the complaints upon which they have acted, the allegations of nepotism, they have acted, and this inquiry, and then, my lord,
that has attained the finality. You are regularly appearing, you are arguing very well. But don't try to argue a bad case, that's all I can tell you.
My lord, I'm not trying to argue a bad case, my lord. I do feel...
No, I feel it's a bad case for you.
Certainly, my lord. Your lordships is...
Maybe you may succeed before the division bench, but definitely not in this case.
So, my lord, if your lordships kindly have a look at the complaint.
Where is it?
At page 43, my lord.
40?
43. The complaint itself was...
1 minute, sir.
Yes. Page 43 is the...
Yes, sir.
Handwritten, my lord. The typed copy is at 45.
45?
Yes, my lord. Now, the results was declared on 4th of April, my lord. This complaint was made on 6th of April, and that is when the result was suspended on 6th of April. Now, what is the contention, my lord, in the complaint? By certain candidates, my lord, with reference to the subject cited above, we, the candidates who came to interview for Ayurvedic so-and-so, would like to bring to your kind notice. Number 1, my lord.
Also, 1 minute.
My lord.
I have read it. I have read all the 3 paragraphs. But one thing, your selection is based on 100% interview.
Correct.
That is bad.
Correct.
That's all. As simple as that. There is no written examination. Through a written examination only, you are entitled to be selected. If they conduct another examination, I will observe in the order, say, relaxation should be given with regard to age.
My lord, but the stigma of this complaint, my lord, that I was related to one of the members, my lord.
That is right. We will clarify that there is no relation at all. That the complaint was given that the health to be not correct. And if the candidate is otherwise eligible, give the relaxation of age and consider the case.
And even the exam which they conducted, my lord, subsequently, nobody appeared, my lord, in the exams.
That is right.
Nobody appeared in the exams, my lord.
See, really in surprise, after coming here for the last about 45 days, I find everyone is good. People are very good. But how teachers are indulging in this kind of practice only, I am not able to understand. They have to mold. They have to bring the clay either into idol or as a monkey.
I leave it to your lordship, my lord. I'm not...
I don't know why they are doing it like this. There in Chennai and Madurai, sitting judges will address the lawyers on certain subjects. So that it will be in criminal law or in this labor law or service law, whatever it is. I find there are a lot of lacuna in the procedure.
Well, it's...
I think I have to address what is domestic inquiry proceedings to everyone.
This is very important, Your Lordship.
Very important subject.
Lot of litigation
See,
can be
number
avoided.
one, the person may be innocent. He'll be victimized, he is entitled to benefits. In some cases, the person would have committed misappropriation, fake certificate, he will be getting the benefit. On the exchequer's money, taxpayers' money will be given to them.
Leave it to your lordships.
Yes. Give the day. I'll go through the paper. If I have any doubt,
Yes, Milord.
I'll get it clarified. Otherwise, I'll pronounce orders on that. We'll post it on a specific date in the month of April. Last week of April, post it. Send the papers.
Well, that judgment, my lords, I'll just circulate it with the judgment I was referring
That judgment and one other judgment. Ask your junior to take out the judgment.
40% and 85%.
No, 25, 15% is for the
Oral interview.
Supreme Court judgment.
My lords, we'll have that. I'm grateful, my lords. I'll oblige.
One more.
Item number 6.
Madam, you must also read and argue. You cannot be assisting him always. I want all the juniors to argue. Who are entering this court must argue. At least one case. Yes.
Item number 6 and 7.
My lord, 6 and 7 are connected, my lord. I have prepared my notes, my lord, in item 7. So if your lordships kindly have item 7. I prepared my notes in item 7. Similar matter, my lord. Prolonged suspension with effect from 2013 till date, my lord. No inquiry, my lord. Aided school, again, my lord, as similar to...
This is item 7.
Item 7. 6 and 7, two teachers.
Both are connected.
Both connected.
Both of them have been suspended, and the inquiry has not been conducted.
Not connected. Aided school, my lord. Same
This is
situation.
case, Your Lordship. I'll place my case, Your Lordship. That is not a correct fact, Your Lordship. It is a case, as I have submitted earlier, Your Lordship.
Committed?
It is a case of abandonment voluntarily of the service, Your Lordship.
Have you conducted inquiry?
Of service, Your Lordship.
Have you conducted inquiry?
What happened, Your Lordship, in 2012? In 2012, they filed a writ petition, Your Lordship. They filed a writ petition. This Honorable Court, Your Lordship, ordered an inquiry. That inquiry has been conducted. If Lordship can you come to...
That was with respect to salary, my lord.
So I'll take this matter on 8th.
8th.
8th. Give the judgment. See, to get the judgment of the Supreme Court, AIR, 1966 Supreme Court, I think 400 and odd page, I don't remember. Case name is Jaishankar, Constitution Bench judgment. You got?
Yes.
You see that? I think last time I mentioned, is it not?
Yes, my lord.
Lordship, I'm relying also in judgment of this Honorable Supreme Court, Your Lordship, regarding the abandonment of service. That
is right. The number of cases are there, but this is a Constitution Bench.
Lordship, because I...
See, the judgment of the Supreme Court is a diamond. Only with the help of another judgment of the Supreme Court, another diamond only we can cut the diamond.
Lordship will do it on the...
So, for that, we'll have to refer to a larger bench.
Because what happened in 2012, during the penalty...
The judgment of the Supreme Court is a precedent, you know.
Lordship. No, I'm talking about this, the fact of this case, Your Lordship. 2012, that writ petition of 2012 was disposed in the year 2014.
Sir?
First, this...
Anyway, I'll go through this. I'll go through. If you have any citation, you read, give it, I'll read and come. On 8th or Monday or Tuesday, we check. Depending upon that, you give. Monday, 8th.
It is Monday, Your Lord.
8th. Please, the earlier case he argued. That paper you send it.
Paano ko yung anything I argue?